Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at some recent changes to the long residence immigration rules and also an update to the Home Office long residence policy. And in doing that, I'll highlight some recent long residence case law. All the links I'll put below this video. And as with all of my videos, do check for changes. You may be watching this a few months or years down the road, and there may have been changes to the rules or case law or guidance, so do check for the latest version. So on your screen now, and I've shared my screen, is the explanatory memorandum to the most recent statement of changes to the immigration rules, HC 1160. As you're aware, when there's a change to the immigration rules, a statement of changes is laid before Parliament, and accompanying that will be an explanatory memorandum. So it's a good summary of the changes. So in the center of your screen, paragraphs 7.65 to 7.68 set out the changes to the long residence rules. So it says this: the current definition of what constitutes lawful residence in the long residence rules is not clear. Well, we know the Court of Appeal have been very critical of the long residence rules. And this has led to confusion for customers and a broader interpretation than intended. So the Home Office are wanting to narrow down the court's interpretation of the provisions. These changes will make the definition easier to understand and better represent the purpose of the long residence route. So let's look at some of the changes. 7.66, the rules are changing to not allow any period on immigration bail to count towards the qualifying period for long residence in any circumstances. This creates a simple expectation that people cannot count time with precarious status towards settlement on the basis of long residence. So in the past, you could count temporary admission, which then became immigration bail. You could count that towards your 10-year qualifying period if you were subsequently granted leave. That is no longer the case. And these changes come in or came into force on the 13th of April, 2023. So you may have a client coming to your office now who says, yeah, I've got to 10 years, where actually you need to check to see if they're trying to count any period on immigration bail or temporary admission, which no longer will count, and they may still have a bit of time to go. 7.67, the changes was also not allowed time as a visitor, short-term student, and on the seasonal worker routes to count towards long residence. So you can't count leave on those routes towards the 10-year qualifying period. Interestingly, there was a case called Mungur. That was a case from 2021. It's 2021 EWCA Civ 1076. That was a case where somebody was trying to count time as a visitor, and they'd gone back within the period of their visit leave and got leave as a student and come back to the UK. And the question before the court then was whether there was a reasonable expectation at the time of leaving that they'd be lawfully able to return. And in that case, the court found in favour of the claimant, and he could use his time as a visitor. But now time as a visitor has gone completely in terms of 10 years lawful residence. And it says this, back to 7.67, this makes it clear that time spent on a route which both allows for a maximum grant permission of 12 months and where switching is generally not allowed, brackets, so there is the strongest possible expectation that the person will leave the UK at the end of a short stay, cannot count towards settlement on the basis of long residence. A person who has spent a period of time on immigration bail or as a visitor or other temporary permission who is later granted permission on another basis will still be able to qualify for long residence settlement, but they will need to wait longer to do so. So again, somebody who perhaps initially came as a visitor may rock up to your office tomorrow, and you're actually going to say, well, you've got 6 months to go before you reach your 10 years, because you can't count that period of time as a visitor. So let's turn to the immigration rules themselves. 276A defines continuous residence and lawful residence. So for lawful residence, you've got to have existing leave to enter or remain, or an exemption from immigration control. But look at Roman 1 in relation to existing leave to enter or remain. You can't include time under Appendix V, Appendix short-term student English language, or Appendix temporary work, seasonal worker. And then look at C, lawful residence does not include time spent on immigration bail. Just before we go to the guidance, actually, let's just go back up to continuous residence. For continuous residence, you mustn't be absent for a single period of 6 months or more than 6 months at any one time, and you mustn't have spent a total outside the UK of more than 18 months. We'll come back to that in a moment because that's clarified in the new guidance. So here is the new long residence guidance. You'll see it's been updated on the 17th of May 2023. Again, I'll put the link below this video. And if you go to 1.3, you'll see the bullet point changes. So what's changed in this version of the guidance? Well, it reflects changes to the immigration rules to not count temporary admission, temporary release, or immigration bail as lawful residence. Changes to the immigration rules to not count leave as a visitor, short-term student, and seasonal worker as lawful residents. So we've talked about those already. It clarifies that 6 months equates to 184 days, and clarifies that 18 months equates to 548 days. So that's why I read you that section of 276A in relation to continuous residence. And you mustn't spend more than 6 months in any one period, or a total of 18 months. Well, those periods of 6 months or 18 months, they mean 184 days and 548 days respectively. And that's to implement a decision of the upper tribunal in Chang. That's Chang 2021 UKUT 65, where upper tribunal Judge Rintel held this, and I'll read you the head note. In paragraph 276, capital A, little a, Roman 5, the reference to 18 months must be interpreted as meaning 548 days. Let's go back to the guidance. There's additional information provided in relating to withdrawn decisions, and additional information relating to Akinola in out-of-time appeals. So Akinola was a decision of the Court of Appeal in 2021. It's 2021 EWCA Civ 1308. And guidance was given by the Court of Appeal and the judgment of Sir Stephen Richards in that case in relation to Section 3C, statutorily extended leave, where you make an out-of-time appeal to the tribunal, and the tribunal extends time for appealing. What the Court of Appeal held there is that your 3C leave is resurrected when the tribunal grant that extension of time for appealing, and actually your leave is extended from the day you lodged your appeal. In that case, the Court of Appeal also looked at the impact of Section 3C, where the Secretary of State withdraws a decision. So if you've got a refusal that brings your leave to an end, your 3C leave to an end, and the Secretary of State subsequently withdraws that decision, Section 3C leave is resurrected from the date the Secretary of State withdraws the decision. There will be then a short gap, and we'll look at that. The short answer is you won't be prejudiced, and you'll be treated as if you were lawful for that short gap. The Court of Appeal also looked at reconsideration of decisions in this case, and reconsideration of a decision has no impact on Section 3C. So this is very important when you're perhaps settling a judicial review claim, you really want the Secretary of State to agree to withdraw her decision, so your Section 3C leave is revived. Let's go back to the long residence guidance. It also provides a clarification of time spent in the UK under the European Economic Area regulations. And just one case in relation to that, there was a recent decision by Upper Tribunal Judge Blundell. That's a case called Ali and others, 2022 UKUT 278. That looked at the EU law principle of equivalence. And when you apply for a residence card, or when you applied past tense, you can't do it anymore, under the EEA regulations, there's no equivalent provision like Section 3C. So you're not treated as if leave is extended during that period. So have a look at that decision of Ali and others of Upper Tribunal Judge Blundell. Let's just go back to the long residence guidance then. So these changes are set out throughout the guidance. So you've got the definition of continuous lawful residence, and this sets out now the exceptions for visitors, short-term students, seasonal workers, and that immigration bail does not count. There's then the section on breaks in continuous residence, and there's a section on 5.5 withdrawn decisions, where a decision has been taken which has brought Section 3C leave to an end, and that decision is subsequently withdrawn. The Section 3C leave will resurrect from the point the decision is withdrawn. And that, as I said earlier, when I looked at Akinola, will leave a short gap. And it says this means you should treat the person as having been lawfully in the UK for the purpose of deciding the immigration application, including an application under the long residence rules. So they shouldn't be disadvantaged by that. And that mirrors the Secretary of State's Section 3C guidance. So here's the Section 3C guidance. This actually goes all the way back to 15th October 2021. And there is a similar section within that guidance called withdrawn applications, withdrawn decisions we want to look at. And it confirms that where the decision is withdrawn, Section 3C is resurrected from the date the decision is withdrawn. But if you look in that large paragraph, the person should not be disadvantaged by the break, and they should be treated as being lawfully in the UK for purposes of deciding the immigration application. Let's go back to the long residence policy. There's a section on out-of-time applications. And section 12, time waiting for a decision on an application or appeal. And it looks at section 3C leave, and it covers out-of-time appeals 12.3, and it refers to Akinola. So as we know, if the first tier grants an extension of time, section 3C is resurrected from the date when the notice of appeal was filed, not the date when the extension of time was granted. And then there may then be a short gap, and this sets out where discretion should normally be exercised and that gap be disregarded. Section 13 of the guidance deals with time spent in the UK with a right to reside under the EEA regulations. That does not count as lawful residence under paragraph 276A. But it says this: when considering a long residence application, however, you should apply discretion and count time spent in the UK as lawful residence for an EU or EEA national or their family members exercising their treaty rights to reside in the UK. Sufficient evidence must be provided to demonstrate that the applicant has been exercising treaty rights throughout any period that they are seeking to rely on for the purposes of meeting the long residence rules. Obviously, any grant then would be outside of the immigration rules where you're counting a period under the EEA regulations. So do have a look at this new policy guidance. And when you're making an application under the long residence provisions, do refer to this in your representations. I've referenced some of the key case law, and of course, be aware of the headline changes in terms of not being able to count time on these short-term routes, visitors, seasonal workers, etc., and not being able to count time when you're on immigration bail. I hope that is helpful to you. Thank you so much for watching this video.